This audio discusses what to do if asked to relinquish your green card when you are seeking to re-enter the United States and sign Form I-407, abandonment of LPR status. That's legal permanent resident status. So what options do you have if you have been outside of the United States for an extended period of time and an officer is now trying to get you to sign the form because they believe you have abandoned your green card status? Ayla has advised, this is the membership for immigration attorneys. They have advised that upon return to the United States, lawful legal permanent residents, LPRs, should not automatically surrender their green card if asked to do so. And an individual does not lose LPR status as a result of time abroad. That they remain an LPR until a final order of removal is issued, and the government must prove abandonment by clear, unequivocal, and convincing evidence, which is a higher evidentiary standard than clear and convincing. The Form I-407 must be signed voluntarily, and there are no potential negative ramifications for refusing to sign this. Neither failure to sign nor abandonment is grounds for detention. Rather, an LPR who refuses to sign Form I-407 must be issued a notice to appear NTA so that an immigration judge can determine whether they have lost their LPR status. When abandonment is raised, you should offer evidence that you have ties to the United States. What was the purpose of your visit outside of the United States? In other words, your intention was always to come back home because the United States is your permanent residence. And the expected termination date of the visit abroad. In other words, it wasn't finite. You weren't planning to stay there for never and ever. Your intent was always to return home. Or facts showing why a date certain is or was not possible. Sometimes things happen. Life is lifing. A family member may become critically ill, and the LPR has no other option but to be there for their dying loved one, so to speak. Because the I-407 must be signed voluntarily, when clients come to me and tell me this scenario, and they say, Caro, I was at the airport, tried to re-enter, I'd been outside for an extended period of time, and the officer was so lovely, so helpful. You know, they said that I just needed to sign this abandonment, that they would admit me in under a visa waiver, or they would parole me in temporarily, or whatever little scenario they had. And they said, just go on back up to the consulate and they'll help you. They're doing that because they want to get your green card and they want to move you along as quickly as possible, and they don't want you to cause a scene, and they don't want you to realize that if you are refusing to sign, then they can't force you, and that they have to issue that NTA, notice to appear, so an immigration judge, now under the remit of EOIR, is going to adjudicate whether you will retain your LPR status. So I would be in full agreement with Ayla, and I would tell you, do not just relinquish your green card. Many times when people are speaking to me, the damage is done, it's too late, and now we're trying to figure out how do we keep this green card, or do you qualify as a returning resident? So it's very important, if you are at an airport, port of entry, and an officer is telling you, sorry, we can't admit you today because you have you've been outside for a long period of time and we're going to abandon it and you need to sign this I-407, and they're all sweet and nice. You need to say, sorry, no, I'm not abandoning my green card. And let them then give you your options. They can't force you to sign the I-407. Once you sign it, you make life very difficult in getting back your green card because you have voluntarily relinquished your green card. Now you're coming back crying, going, I didn't mean to. I spoke to a lawyer. Now they've told me different. No. From inception, don't sign. Refuse to sign. And speak to me then. So the legal burden is on you as the green card holder who's now fighting to keep your green card, and it's by a preponderance of evidence, which is more likely than not. It's like more than 51% that you did not abandon it. So it doesn't have to be removal of all doubt. Just 51% that you did not abandon. So officers are going to look at the totality of the circumstances. And if the officer is still not convinced, then you should be asking for a hearing before an immigration judge. If the green card is confiscated, then you must be provided with an alternative evidence of your LPR status, such as a 994 and or passport stamp that says evidence of temporary residence. So even when they can't force you to sign this I-407, they may refuse to give you back. They're confiscating that green card. But they must provide you with an alternative evidence of your LPR status. Abandonment of residence is not a ground of inadmissibility. Inadmissibility issues normally trigger waivers, so abandonment of residence is not a ground of inadmissibility. So what are your options if you have been outside the United States for over 1 year? Well, before I give you the options, I will tell you that in the event you know that you're going to be outside of the United States for a long period of time. Typically, if you're going to be outside the United States for over 180 days, but less than 1 year, there is a rebuttable presumption that you have not abandoned your lawful permanent residence. If you are outside of the United States for over 1 year, then immigration officials at the port of entry will deem it to be automatically abandoned. Now, they're misinterpreting the statutes and the law. However, try and explain that to them on the day. They're not going to listen. They're going to try and confiscate, and at the very least, confiscate the green card, as I've stated, but they will try and get you to abandon your green card. If you feel you are going to be outside of the United States for a long period of time, then you can preserve your green card, and I discussed that in another free audio, so have a listen to that. But what are your options if you have been outside of the United States for 1 year? Something has happened, you didn't plan on staying outside for so long, life is lifing, you stayed out for over a year, what are your options? Well, you can do an SB1, that's a returning resident at a US consulate, US embassy. There are certain grounds that you have to adhere to. So you may be eligible for a returning resident, an SB1 immigrant visa, which is essentially a new immigrant visa that you are going to be applying for on the following conditions. That you had the status of a lawful permanent resident at the time of departure from the United States. That you departed from the United States with the intention of returning, therefore you have not abandoned your intention to return. The intention is critical here. If you present yourself to an officer, did you plan on returning? No, I didn't. I planned on staying outside the United States, but you know what? I miss it now. Then you have not satisfied the legal requirement for a returning resident SB1. So when you departed the United States, you must have had the intention of returning. It doesn't matter even if it's way down the road, you had that intention. You also must show that you are returning to the United States from a temporary visit abroad, and the stay abroad was protracted. It was something happened, whether it was maybe a family illness, maybe you had to take over a family business, something happened. And it was caused by reasons beyond your control and for which you were not responsible. And then you have to submit documentation to the US consulate, and they will determine whether you qualify. If you believe you have a case for SB1, then contact me. And we do a lot of these. They are adjudicated unpermissively, meaning stringently by the officer. They're not just going to give you back a green card. In their eyes, you've lost your green card, so they're not just going to be, here, come, we'll give you back your green card. You have to fight for it. You have to prove it. So what you don't want to do is go to submit this to the consulate and get it denied, because you're causing all sorts of problems for yourself. Another good option, if you have been outside the United States for over 1 year, I've done this successfully. You have to craft this very carefully. You can be admitted on parole if the port of entry immigration official did not abandon your green card, and you can request deferred inspection. You will provide your I-90 application with a legal memorandum. Deferred inspection sites are typically within a 10-mile radius of most airports in the United States. Once you are paroled in, you will be given a deferred inspection hearing interview. You must attend, and that's when you will present your case. So when I deal with these types of cases, I will draft a legal memorandum. I'm arguing the facts. I'm making it as humanitarian as possible. I'm at the mercy of the officer. I'm pleading and begging for my client to get back their green card. It will normally include me prepping you because you're speaking to an immigration official. And we have been successful getting back green cards where people have been even outside of the United States for 4+ years. I believe the longest we were able to get a green card back was like the guy was out for a good 8 years, but the circumstances were absolutely extenuating and we had to fight tooth and nail. But he listened well and he successfully was able to retain his green card. He was not bullied into signing the I-407. He did not abandon the green card. Therefore, we were able to put together a case and he was paroled into the United States and fought for it at the deferred inspection hearing. So the key takeaway on this is if you have been outside the United States for a long period of time, you're re-entering, the officer now wants to take that green card from you and deem it to be abandoned and get you to sign an I-407, you should refuse. And